What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
I accidentally paused it. What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Thursday. Yep, I'm on camera tonight. For multiple reasons, but I'm on camera tonight. How's everybody doing? Hope you guys are having a great night. I have got a Judge Webster clip. It's a Jay Regier clip. And yeah, Jay Regier is in a little bit of trouble. He is. He got himself into some trouble. This clip happened yesterday. This hearing happened yesterday. And I played part one a few weeks ago. Now, this is a DUI case where the defense didn't receive the discovery. Judge Webster was upset. They continued it. It was about 2 weeks ago. They continued it till yesterday. And did they get the discovery? I don't want to spoil anything for you, but we've got the hearing. It's a long one. It's about an hour long, so it's going to take the entire clip, but it's good. It's good. Anyways, thank you guys for joining me tonight. Yes, I'm on camera. I wanted to show off the fact that this is actually a hoodie in my picture and not a scarf, so I actually wore it to show it, since everyone thinks it's a scarf or an ascot. It's not. It's not. It's a hoodie. See? It's this exact same thing. That's what it is. Oh, guess what, guys? Guess what? Gabby Davis.
Don't mind me. Just getting a little water and getting settled in.
How are you doing this evening?
Not too bad. How about you guys?
I'm doing well. The chat seems happy.
Excellent.
So I'm gonna guess they're well. How are things? You've been a little busy since last time you were on a live stream with me.
Yeah, for sure. Very, very busy. Back at work at the prosecutor's office, and just
where you belong.
I'm enjoying it. So, yeah, just a lot of meetings. There are a lot of meetings about meetings, to have meetings, but it's good. I mean, I enjoy it. I really do. There's been some pretty tough cases that have come up, and so I'm glad that I'm there and can work on them.
Well, I'm glad you're there too. I know the chat's glad you're there. Everyone's saying hi to you. So, yeah.
I don't think I can see it. What do I do?
You just click the comments on the right side of the screen. Oh, you're on your phone?
Yeah.
Yeah, I don't know how to do it on phone. But there's a button that says comments. But I don't know how to do it on the phone.
Well, you're fine. And then I can't see what you're doing though. So, all right. So we have something to.
I'm not the important one.
Turn off my do not disturb or whatever. Not well prepared. There we go.
It's all right. I invited you on stream ago. I was like, there's no way she's gonna say yes. You're like, oh, if I have time, I will. I'm like, I wasn't expecting that.
Why not?
So thank you so much for joining.
We're watching the Michigan game, so Harper's playing on her computer and Chief is being good. So sure, why not?
Let's watch some court. So I kind of gave you what we're watching tonight. This is Judge Webster and Jay Regier, and it is a boating while intoxicated case. And I played a hearing from the same case about 2 weeks ago, and Jay Regier had yet to send the discovery to the defense. And the trial was this happened yesterday. The trial was supposed to be yesterday, and 2 weeks ago, the defense didn't have the discovery yet. Judge Webster was not happy. Kind of laid into Regier a little bit. Now, I'm going to let this play before I ask you a bunch of questions about the process and how this works.
Sure.
But is it on you to send the discovery to the defense, or is it like a whole office type ordeal? So
it's different at different offices, but at the end of the day, it's me. It's the prosecutor who is responsible for our staff. So if there is a breakdown in something, we're the ones that are responsible for it. So,
Okay.
yeah, but typically you have a point person on your staff that sends it. So I guess I'm curious, like, why it wasn't, what type of discovery was it? Digital evidence, videos, police reports? Like, guess we'll find out.
You're gonna see everything. The hearing 2 weeks ago was very vague. They wanted what was it? It was the toxicology results. They wanted the actual toxicology results, and they weren't receiving that. But they had the police reports. They had everything except for the toxicology results, and that's what they were complaining about. And they walked through the entire process today, so it's interesting. So yeah, your opinion is going to be very valued in this one.
Oh, well, hopefully I can give an intelligent one.
I hope so too. You will. You will. I know you will.
How's
Okay.
that?
You ready?
Yep.
All right, let's go.
We are on the record in the 13th Judicial District, the District Court of Butler County, Kansas. This is our Wednesday afternoon traffic trial docket for November 20th, 2024. Mr. Regier, are there any special orders you want to take these cases up in?
Your Honor, whatever order the court would prefer.
Well, let's take up the Sawyer matter on the record in 2023 FG 300002, State of Kansas versus Dallas Dallas Curvin Sawyer. Jared Regier appearing for the state, the defendant in person and with counsel, Peter Hagen. The defendant is charged with voting under the influence. I believe we are here because of a matter I had taken under advisement. The defendant had requested and the court had ordered multiple times that certain evidence be provided to the defendant. And that mainly involved blood test results from the Kansas Bureau of Investigation. And I understand that every time I ordered it at each hearing, county attorney, the assistant county attorney was told by his staff that it had been provided in March or something of that sort. But in fact, it was never released and provided when I ordered it. Am I remembering this all correctly, Mr. Regier?
Your Honor, the state's understanding is that at the previous hearing, counsel for the defense had proffered an oral motion to the court for dismissal. I have had the opportunity to review this matter further, and the state would be requesting the opportunity to respond in full to the oral motion.
Mr. Hagen, do you want to just, for the record, renew your motion?
Yes, Your Honor, we'll just renew the motion. I did not get the blood test results and had requested them from the state. On 6/17, we were in court, and I told Your Honor and the state I still don't have the blood test. They said they would provide them, and you ordered them to provide that. I believe we came back on 8/19, and I still did not have the report and requested him from his office, and they had provided us everything with our on 8/19, you ordered again the district attorney personally, as you did on 17th of June, to just give me the blood results. And I did not get them. And then on 11/1, we were here when you were taking this under advisement, and I was provided when we took a break for Mr. Regier to talk to his people about it, and he emailed me the result on that day.
So you did get the results the last hearing after the motion,
Yes.
and your position today?
Well, it's been, I believe you counted the time, Your Honor, and it's been past the 6 months that the state would have, and it's been all their, the reason that it was continued is because they didn't provide what you ordered them to provide.
Well, I know that sometimes it is difficult for the prosecutor to get certain information or evidence from specifically the Kansas Highway Patrol. And I take into consideration the efforts of the state trying to obtain those. But as I understand in this case, the state had that report that the defendant was requesting all along, but just wasn't releasing it because somebody kept saying they'd already sent it. And defense counsel kept saying, well, you may have sent it, but it didn't come with what I have. So that's why I said, it's not, don't argue about it, just do it. Just send it again. So Mr. Regier, go ahead, please.
Yes, Your Honor. As previously indicated on the record, in the interim between this hearing and the last hearing, my office did have the opportunity to research the matter further, and to that end, the state is prepared to recount the entire discovery process in this matter. To that end, my office has prepared a report detailing the entire process based off of screenshots of that using the discovery software utilized by my office, not only in this case, but in all other cases. I am prepared to share that on the screen. Would the court prefer a copy of that report be emailed to the court?
Hold on, Debbie, I muted you.
That's okay.
You've got a little bit of feedback coming from your mic. So I muted you. You have I don't know if you know this, you have your own emote on my channel, and that's what that is. That's how it comes across on our side, but on YouTube, it's actually a little picture of you.
Oh, okay. I'm like, why? Always a little name, but that's fine.
Yeah, it's a little picture of you. Okay, that's all I wanted to say. I saw when I brought that up, I saw you smile. I was like, I figure I should probably explain that.
Yeah, nice. All right. Well, that makes more sense. I'm like, whatever it is.
There's really nothing yet to comment on. But did you have any comments as of yet?
Yeah, I mean, sometimes they're like, well, we already sent it. Well, to me, it's like, okay, well, they didn't get it, so just resend it. It's probably takes about 30 seconds, honestly, to resend something, right? So it's interesting they have some sort of software that they use to track. I'm curious what they use. We're switching softwares to Carpel, like Prosecutor by Carpel, which does track kind of where you send your digital evidence. Right now, ours in OnBase does, but it's not ideal because not everything is in OnBase. So,
well, he's about to show you the entire process,
Oh,
and I had to go through it to make sure that there wasn't any doxing information. I'm pretty sure that there's not, but if there is, I might have to pause it real quick and kind of cover up the screen. But we'll take it as it goes.
What's the harm to the defendant? Like, it looks like he's not in jail, so he's not jail waiting for this because somebody's not doing their job. The results aren't going to change, right? Like, so I guess, why is this still an issue? Just do your trial. If you've got everything you need now, go to trial. But
yeah, I think he's saying he still doesn't have the blood alcohol results. He doesn't have the. Oh,
I thought that's
whatever report
the prosecutor emailed to him after the last hearing.
I thought he said he still did. I thought he said he still didn't have it. Maybe I misheard.
Okay, well, I guess we'll see.
I will say at the end of the last video, at the end of the last hearing, Judge Webster said she was going to take this under advisement. So maybe she did, and her idea was to put together, to actually have a hearing on it instead of just making the decision on her own. So that might be what this is. But this is the trial docket. So that's why I just assumed that this was at least a trial prep.
Gotcha.
But well, I guess we'll see. Sparkle Poots, congrats, Debbie. So glad you're here with us.
Yes.
What are we congratulating her for? Did you do something big?
Oh, no, just got a job. I mean, that's all.
Oh, congratulations on getting a job. I'm teasing. That is awesome. I was very happy. I blew up your phone so much that night, and I still feel kind of bad for how many texts I sent you. I sent her like 10 texts.
It's totally fine.
Shane Halls, thank you for the 10 months. That is awesome, my friend. Thank you so much. All right, let's keep going. Let's see, play.
I would actually prefer screen sharing if you have that available.
I do, Your Honor, if the court will permit me.
Yes, go ahead.
One moment, please.
We all have questions. We do.
Oh my.
Your Honor, is the court able to see the document?
All right. Just set up to try to make this a little bigger. I can do this.
Oh, I can zoom.
So we can see it a little bit better.
Docs you share? I zoomed in so I can see. Case number. That's pretty detailed. All right.
You ready to go?
Yep, let's do this.
On the screen?
Yes.
Thank you, Your Honor. Your Honor, if the court will respectfully direct its attention initially to the entry at the bottom of the screen, log type insert.
I see that.
Your Honor, the court will note that the updated date on that one is January 3rd of 2024. I believe that would have been prior to the hearings referred to by counsel for the defense. The state, after conferring with my colleagues, I have confirmed that is the point at which the discovery file was created. Additionally, if the court will direct its attention to the upper left-hand corner of the page, the court will note that it includes a notation stating case authorized on January 3rd of 2024. It is the state, I have confirmed that is the point where this particular file was authorized.
Okay, you lost me there. Okay. I see the January 3rd at the bottom. And what was the other thing you referenced?
The case authorized.
All right, I put our little icons down here so it made the screen bigger, but I feel like I'm covering what they're talking about. So I'm going to put us back for now.
That's fine. I can still zoom.
All right.
Notation in the upper left-hand corner, Your Honor.
Upper,
With the same
Oh,
date,
okay.
January 3rd of 2024.
okay, I see that now. Case authorized.
Thank you, Your Honor. Your Honor, if the court will permit me to fast forward to page 6 of the report.
Okay.
Your Honor, this is the ledger part of the same report that identifies authorized users of the discovery file. The court will note that there is one authorized user included for this, counsel for the defense with an email address on the screen, and that counsel for the defense was added as an authorized user pursuant to the date created screen on January 3rd of 2024 at approximately 1:29 p.m.
I see that.
Thank you, Your Honor. Going back to page 1 of the ledger, the court will note that above the entry labeled insert, there are a series of 5 upload entries beginning from approximately January 3rd, 2024 at 1:32 p.m. and concluding on January 3rd, 2024 at 1:39 p.m.
I see.
Among those uploads include multiple files labeled video, as well as a file labeled 23FG300002, which the court will recall corresponds with the case number for this particular case.
Noted.
And Your Honor, and fast forward to page 5 of the report. This is the contents of the discovery file, as I understand it, including at least one file labeled media and another application/zip entry with that same number, 23FG300002. Both of which status dates of January 3rd, 2024.
But what is this telling me?
This, Your Honor, what I have confirmed that this is the contents of the discovery file as provided to counsel for the defense.
What is the contents? The information on the previous page or the information in this blue box?
The information on the screen right now, Your Honor, and the state would also direct the court's attention to page 8 of the report, which will show the contents of the file 23FG300002.
All right, so the page you have on the screen is showing me that something electronic.
You know what this feels like? This feels like every time I had to do a presentation for a project that I was working on when I was a programmer. This feels like a flowchart, a basic flowchart. You know, I show them the flowchart and then I walk them through the different pages. That's what this feels like. That's what Jay Regier is doing to Judge Webster right now. You click this button and then it will take you here, and then you click this button and it'll take you here.
It's like, okay, I see a strip of blue that says something on it, but where are the actual documents, videos, things that are included in that? So hopefully he's going to click on it.
Hopefully.
Was sent to defense counsel?
It is showing the contents of what was sent to defense counsel. And if the court will allow me to go to page 8, I will be able to show the court the contents of.
Well, all I'm seeing on this is name, status, date modified, modified by, and name type. Which of those tells me what defense counsel received or what was sent to him?
Your Honor, both of these were sent to defense counsel, and if the court will permit me, I can move to another screen that will show the contents of
All right.
the highlighted portion.
Okay, so this doesn't really show me what was sent, but
It shows that.
Well, I never received the blood.
Go ahead.
It just, so he is taking a really long time to answer the question. I feel like there's got to be a quicker way to do this.
Yeah, he doesn't have to go through step by step. This is how the program works. He doesn't have to do that. Judge doesn't care how the program works.
He's trying to say that, hey, we gave access to this file on January 3rd. And every time we put something in that file, he's got access to it. Okay, that makes sense. But then when did you put the toxicology or the blood results in there? And can you tell, is there something in the program where you can see if he actually downloaded it or if he actually opened it and looked at it? I'm not familiar with this program, so I don't know.
That would solve this entire issue if it had that feature. So maybe we should reach out to Mr. Regier and be like, hey, add this feature to this.
Yeah, exactly. I mean, it's probably only like $10,000 more a year. I mean,
yeah, to add one line of code.
I was looking at stuff for Carpel. I'm like,
before we go any further, I just got a Venmo from Craig. Craig, thank you so much for the Venmo. I appreciate it. It's for the gas fund. So I announced that I'm coming to visit you on Tuesday. And
well, that's going to be fun. I'm excited.
Yeah, I am too.
Prelim, though. There's only one prelim that's scheduled, and I don't know if it's going to actually go or not.
Well, regardless, I'll be there, and hopefully I'll have a chance to meet you at least, even if you're not physically working. Well, you'll be working, but
I will be working year round, so yes, don't worry. I will be there.
All right. Well, I'll be there too. So Tuesday. Can't wait. But yeah, so I announced that last night. Or yeah, kind of last night. Anyways. Craig, thank you so much. Let's go.
Test, Your Honor. And I did get a lengthy report, but those weren't in it. And that's why in June and August, the DA was ordered to give that to me. Whether it's in there and I'm supposed to go through there, I went through every page that they sent me because they sent it to me.
Well, and that's the only issue is, why didn't you just give him the alcohol and drug report when I said to? But maybe you'll
You
answer
ordered it.
that.
You ordered it twice, Your Honor,
I
and I
know.
even had my office call after the first hearing, and they said, no, we've already provided you everything.
Yeah. Forget what the judge says. We've already done it. So go ahead, Mr. Regier.
Thank you, Your Honor. Moving on to page 8, these will show the contents of the file 23FG 300002. Including multiple files labeled affidavit, blood draw, KBI lab, Sawyer, KSAR, and so on.
Okay, now did you put this green highlight on there for purposes of the hearing, or would it have been like that when it went to defense counsel?
For purposes of the hearing, Your Honor.
All right, so you're telling me that if I click on that, if I had access to this and I clicked on blood draw and KBI labs, I would get what I need to know about the lab draw and the results?
Yes, Your Honor.
And you're saying that this is the same thing that defense counsel would have seen if he clicked on it?
Yes, Your Honor.
And that went, well, now this says, what's that? Why does it say 9/25/23 that it was modified? What's that got to do with the case? Had it already been done before the case was filed?
Your Honor, the date modified, as I understand it, is the date that the file was last modified. If the court will recall, going back to page 1 of the report, the insert and upload entries dated January 3rd of 2024. Those are the dates that the file was initially created and that the documents were uploaded to the file.
Okay.
All right, I've got to pause it. We just got a Big In raid, so I got to shout out Big In. Big In, thank you so much for the raid. I appreciate it, bud. Welcome to all the raiders. Let's see. How do we
bring
summarize
people
this?
speed on this one? Well,
Yes.
let
You
me
wanna
take
do it? Go
I'll
ahead.
stab at it. So this is a motion about the defense not getting discovery that they believe they should have gotten earlier on, and now the prosecutor is trying to say, hey, we did give it to you and here's the proof. But it's a very slow and long and painful way for the prosecutor to go through each screen to show it was uploaded in January, somehow though it was modified in September, which is interesting. I don't know why you would have modified it unless they got updated. So I don't know. I mean, that sometimes labs do take months to come back. Like, you have the proof that you sent it to the lab and you have your initial, whatever. But if you're going to get a confirmation, sometimes it takes months.
Sorry, I was reading the chat.
No, you're fine.
No, it does. And I've heard that in almost every court that I've watched is we just order this test. It might not come back for 2 or 3 months, so they have to, schedule a hearing that's 3 or 4 months away and hope that they have it. They still might not even have it during that time.
Right.
Hey, what's up, KFAR? Good to see you, KFAR.
And one of the other issues is too, like in big cases, the lab in Michigan anyway is limiting them to sending only like 2 pieces of evidence per case. So if you've got, touch DNA and you've got body fluids and you've got this, you have to choose, or if you have more than one item to send. Now they do make exceptions for that, but it's for like homicide cases or something where there's a traffic fatality. And so the officers, even in simple drug cases, say that a person has 3 different types of substances, they can only send 2, which frustrating.
Can I ask why? Why would that be a limitation? That doesn't make sense. If there's evidence there that could prove that someone's guilty, why are you limited?
Well, because they don't have enough staff, they don't have enough time to do all of them, and so they're so backlogged that at one point Michigan farmed out
Okay.
the stuff to, gosh, was it Pennsylvania maybe? I don't remember now, but like outsourced it to other labs because they got so far behind. Because Michigan State Police Crime Lab is doing basically every single OWI to, CSC and everything in between.
Okay, that makes sense. I understand that now. That sounds like a nightmare having to outsource it to another state. Could that mess up the chain of custody at all with the samples?
Could, and now with that, Arizona case where it's like, if the person did the testing, you got to have that person here. That created an issue because now we're flying in people from New York, Pennsylvania, wherever, to testify about how they did this particular testing, and we have to pay for that. So if the client of the defendant doesn't agree to let the person appear by Zoom, or the court doesn't let the person appear by Zoom, we have to physically get them there.
It sounds like a nightmare.
Yes.
Well, congratulations on your new job.
Okay, thanks.
I feel like that was an appropriate time to drop that line.
Perfect timing.
Yeah, exactly. All right, let's keep going. Again, sorry. Again, Big N, thank you so much for the raid, my friend. I appreciate it, buddy. I don't. Everyone knows you. I don't have to introduce you, but I will. This is Debbie Davis. She is the new elected prosecutor of St. Joseph County. Is it St. Joseph County, or is it what's the actual jurisdiction on that area?
St. Joseph County. St. Joseph County.
Okay. And I asked Debbie to join me on panel tonight about an hour ago, so I'm very happy that she's here. But I wanted her take on this case because what's that?
I really dressed up for you. Yeah.
Yeah. Well, I generally dress up when I have guests on, but I just threw a hoodie on. So no, we're good. I lost my train of thought now. So thank you for joining me. This is the wonderful Debbie Davis.
Thank you. So now we're just getting to the exciting part where the prosecutor what is in this file. He's gonna click on something, I think.
It's, as of right now, it's Schrodinger's file. There is everything in the file and nothing in the file at the exact same time.
Yes. Lots of letters.
All right, let's go.
Okay, now let's look at those items. What is in 23 FG3, all the zeros and 2? What documents are in there?
Your Honor, going back to page 8, Your Honor, if the court will direct its attention to approximately halfway up the screen to the file browser.
Okay.
The court will see a file folder 23 FG 300.002.zip.
Yep, keep going.
His AI is processing right now.
And within that there is a reports folder.
No, I see the word reports.
And the court will also note that in the upper left-hand corner of the window, it indicates that the browser is currently set for the reports folder.
Right.
And the documents observable to the court on this screen are the contents of that folder.
Okay.
Including the KBI, the files labeled blood draw and KBI lab Sawyer.
So this is everything that was in that entry that I asked you about.
Yes, Your Honor.
Okay,
Maybe
let's go back to that screen if we
doesn't
can.
understand how to use the program. Maybe.
I didn't hear the beginning of that sentence.
Is it maybe the defense attorney doesn't understand how to use this program, which it seems pretty, there's a lot of buttons to click, and I'm not sure it's the most user-friendly. And if he's not a typical person that does, criminal cases in this court, he may not have any clue how to use this.
That's true. I mean, we have no idea. What's up, Beck? Thank you so much for the super chat. Yeah, we don't know. We haven't really heard anything from the defense yet. All we've heard from them is he said he still hasn't. Well, again, I don't know if he said still, but he didn't have the test results, which is what he wanted.
And I don't know because, I mean, I wish I had time to watch all of these more regularly. But is this an attorney that is usually in this court? Like, you know how in St. Joe County, you can, like, ones that are and ones.
Yeah. This was a first appearance for me playing this attorney. I don't know if I've ever seen this attorney before.
Okay.
And Cody, yeah, absolutely. The second I brought her up, I knew it was the Debbie Davis show. So no, I'm okay with that. I know what I signed up for when I invited her.
And yet here I am.
Yeah. This is why I invited you. I could not begin to explain this case, and I thought it was interesting enough to share. But if it was just me on here, I feel like tonight would have been really boring. So I really do appreciate you being on here.
Yeah, no problem.
Thank you, Your Honor. The court will also note that on page 1, there is an entry approximately a quarter of the way up the page above the upload section, log type email sent.
Log type update view email insert. Where are you?
The highlighted entries, the second highlighted entry from the bottom.
Oh, okay. Email sent. Okay.
And under the updated column in that same column, it includes counsel for the defense's email.
Mm-hmm. Right.
And besides that, there is an updated date of January 3rd, 2024 at approximately 1:55 p.m.
Okay.
Your Honor, further up on that page, there is a purple highlighted entry labeled update
I see that.
with an updated date of March 12, 2024 at approximately 9:46 a.m.
Noted.
Your Honor, if the court will permit me to, forgive me, Your Honor, jump over to page 7 of the report.
Very well.
I'll work on it.
Your Honor, this is page 7 of the report is a phone entry dated March 12 of 2024 detailing a conversation between counsel for the defense and my office.
And I'm not able to read it on my screen, just so you know.
It's pretty small here too.
Does the court wish?
Why don't you read that for the benefit of both of us, Mr. Regier? I mean, I can see it, but it's pretty tiny.
I can enlarge the screen if the court wishes it.
If you can.
Forgive me, Your Honor.
I just fixed our icons, and now you're going to enlarge the screen?
Is that better?
That's better, but I don't know if it's good enough for counsel. Can you see it? That's much better.
Oh, so
Forgive
he
me, Your Honor.
must be a retained
Experiencing a
attorney
slight
who can pay for the discovery.
Okay. I mean, that makes sense why he's fighting so hard. Well, that was a terrible comment to make. That's not what I meant to say. Yeah, I'm not going to even try to say what I was thinking about saying because it came out that way, and I just butchered that. I didn't mean it. I take it back.
I get what you're saying, but well, and the thing is, like, court appointed get discovery without having to pay the cost. So I think it is frustrating for retained attorneys when they're like, look, I even paid. Why are you not giving it to me? So
Can I ask is it a flat rate for discovery, or is it depending on how many files they have?
it's different. It's different for different types of discovery. And it's different for different offices. Sometimes they charge per page in the police report because you have police reports that are 2 pages, or you have police reports that are 200 pages. Actually, one of the cases that just came in from one of the agencies, it was too many pages to put into our electronic system. So they had to bring it on a separate flash drive. And if we print it out, we're talking like 1,000 pieces of paper. So if we have to print that out for someone, there's going to be a cost to that. But if it's court appointed, we can't charge them.
Okay. I mean, I guess that makes sense. It does. I've never thought about that. I didn't know that discovery costs money. So when a pro se defendant asks for discovery, they have to pay for it.
I mean, unless the court says that they're indigent, then I guess they have to. But if they have a retained attorney, yeah. So I want to say, don't quote me on this, but in the past, it was maybe like $10 for a CD. Like if we have to burn something onto a disc.
So we're not talking hundreds of dollars. It's not gonna.
It could be out there because honestly, I don't know. It would seem like if it's just electronic access to it, it should be a flat rate. Like,
right.
To me, it would be whatever cost it is for you to, put this person on as a user. Probably doesn't take that much.
Thanks, peeps. I actually made the decision to shave it. It's coming off December 1st. The little experiment I did to grow my my facial hair out. It's been going for about 4 months. I think I'm over it now, though. So
your No Shave November actually started like in August?
Yeah. Yeah, pretty much. Yep.
Good. Very good.
Yeah. Heather made fun of me for that same thing. I told her, I was like, I'm shaving December 1st. I'll do the no shave November. And she's like, you're supposed to shave on the last day of October to do that, right?
Then there wouldn't be anything to like shave off then, right? Like,
yeah, right.
Good thing you started early.
Exactly. I look like I was paying attention, and let's go. All right. Let's keep going.
Bag.
Okay, and this is dated 8/25/23.
Your Honor, the date is March 12th of 2024.
Oh, okay. Let me get the history. I was doing that as you were calling that up. So the case was filed 12/7/23. The entry of defense counsel's appearance was 12/27.
What's the incident
23.
date on this? Who's driving a boat intoxicated in Kansas in December? This must have been. I bet they waited for the blood results to come back before they even charged it.
Oh, so it was charged during this time. It wasn't.
Well,
that's a good question. Who is driving a boat in December?
Right. I mean, in Kansas, maybe.
In Kansas, that's the important part.
Right. So
Well, maybe that explains he's definitely was drunk because no one else was doing that.
Right. He had to be because it kept him feeling like he was warm because it was so cold.
Exactly.
But
all that crunching on his boat, that's not ice. That's just, rough water.
Keep going.
This email is dated March 12th. So we'd already had defense counsel for 3 months.
I know there's at least
and his office sends out this email stating they paid the discovery fee but never received anything.
And
someone in the CA's office reactivated the case and DocuShare and explained it was sent to the office on 1/3. So she or he is saying on 1/3/24, discovery was sent by DocuShare, right?
Yes, Your Honor. And if the court will recall on page 1 of the report, it did refer to an email being sent on January 3rd of 2024.
Yes, I do remember all that. All right. And 312 defendant. So he emailed the same day discovery was sent? No, strike that. Okay, go ahead, Mr. Regier.
Thank you, Your Honor. The court will note that, again, that this record is dated March 12 of 2024. In returning to page 1 of the report, the court will note the updated entry, which is also dated that same day, March 12 of 2024.
Okay,
The note from the correspondence dated March 12 of 2024 indicates that an email should have been sent with the discovery to the attorney, and the defense counsel office confirmed that it was received and would attempt to pull it off.
okay. And I don't think that's been the issue. They've acknowledged that they did receive a discovery file. Is that right, Mr. Hagan? You just didn't have the one document in it?
Correct.
Okay.
And Your Honor, going back to page 1 of the report, the court will now note that that while the state does acknowledge that historically their discovery has perhaps consisted of just handwritten notes saying that a disc was sent out, my office has progressed far beyond that. The court will note that the first entry on page 1 does.
What's that?
It's like so far beyond a handwritten note. Like, we sent the disc out on such and such date. There is so much here. But again, he hasn't shown what documents were in any of these. So, like, just pull up the thing and say, in a very brief manner, may the court direct their attention to document number 86 of 102. Okay, maybe it was buried in there, but if you gave it to him, you gave it to him.
Or he didn't give it to him, so this is just a whole spiel on.
Right, then
it's not my fault.
And then it wasn't in there. Sorry, but here it is. Something.
Yeah, who knows? I forgot to warn you. When I shut off my camera real quick, it's because my internet starts dropping. I know I told you that last time you were on, but I didn't refresh your memory. No. So I'm not leaving. When I do that, I'm not leaving. It's just my internet starts to lag a little bit.
I was going to turn mine off and go get some ice cream while it was
do it.
Time. So I'm trying to be good.
Go get some ice cream. Turn your camera off.
Might have to.
And have a log type indicating download single started.
All right.
And with being updated by counsel for the defense.
And that would be one of those two lines there. Download single successful. Is that what you're saying is?
The top highlighted line, Your Honor.
The very top line?
Yes, Your Honor.
I bought two.
Okay.
That specifically refers to the file 23FG300002, which would include the reports, including the KBI lab results.
Okay, so that line indicates that someone at Mr. Hagan's office.
Just like, show us. Click on it.
Right. I didn't understand what you said. Like, oh, you just said something. I was like,
well, first somebody asked like what ice cream I got. I got a peach, like vanilla and peach one from Mooville. The Mooville Creamery ice cream is like bomb. When you come, not if you come, because I was to say if, but when you come here, we'll go to Yoder's and I'll show you the ice creams. And I also got a triple threat one, which is like cookie dough and brownie and something else. But anyway, so yes, I do want to eat those. But again, let's go back to the discovery issue. I think this is really a technology issue. And as much as we want technology to help us make things easier and document like who downloaded what and where, it also creates big issues like this sometimes. Just click on.
But if that was actually the case, couldn't Regier just say that? Like, listen, like I thought this was in there. This is clearly a technology issue. It's not something we did on purpose. Now that I know that it's not in here, after thinking it was, here it is.
Right.
Can we adjourn?
I think it comes down to like the due diligence, right? And this is where I'm struggling a little with the agencies because they have so much data, so much digital evidence. They've got 3 different views of cams. They've got the dash cam, they've got the wide dash cam, they have their body cam, they have their in-car cam. And so it's like we have to pay to keep all of this data. They're paying to keep all of this data. And the way they're doing it right now, because we don't have a license for their document management or like this program, every program is different, but say there's like Axon and evidence.com that a couple of them use. They pay a bunch of money to have all of their stuff stored. They can send us a link, just like what this prosecutor sent that attorney a link. Our staff has to click on it and download it. Depending on what type of case it is, sometimes our staff will take 4, 5, 6 hours to download just the data from one of the open cases. One of our clerks today spent hours transferring cases that have been closed over to our like Amazon cloud storage or whatever it is, so that they can free up space in our disk. So if this attorney's office is not familiar with using this program, and they don't typically get these, it may take hours for them to download this, or they may not even have enough space on their drive to do it.
That makes sense.
So if anybody out there works for Axon, evidence.com, if you guys have any coupon codes for me, I would appreciate it, because we're going to have to pay to become an agency, and it'll hopefully avoid hours and hours of work for my staff. But hey guys, we'll, take any donations too.
Hashtag Debbie needs a coupon code.
Hashtag coupon codes. I am a coupon code person, or discount code, or whatever you want to call it. Coupons. It's like
Either way.
coupons.
Your nails are apparently on point.
Thanks. Shout out to Kendra, my girl who does my nails. Colin, if you bring Heather, I'll have Heather get her nails done by Kendra. We call it her Ratchet Nail Salon.
Heather is an esthetician, so she actually that's what she does. She does nails, facials. She does a bunch of different
Somebody
things.
has to do her nails. I mean, Kendra does her own nails, but
This is true. This
nice
is true.
to have somebody else do them.
It is nice. It is nice. You're right. You're right. I'll let her know.
But now I know that when I go see you guys, I'm gonna have to book some services with Heather. That's how it's gonna be.
Well, she does live in Nova Scotia, so maybe if you come visit us up there, then yes,
right?
she'll
Slightly further, but we can make it work.
Office actually pulled the information from the file, right?
Initiating the download process, Your Honor, and I cannot, and if the court will permit me to continue, I will be able to confirm for the court when that was successfully completed.
All right. Well, why don't you show me what it was he got? What?
Yes.
Can you walk me through? Was the report in video 1? Was it in video 2?
Your Honor, the report, Your Honor, in the on page 8 of the affidavit, the report is in the reports folder in the file 23FG 300002.
Okay, but is there? Show me that. Okay, this black file has all this stuff in it, right? Whatever's on this black screen has all of this stuff in one file, right?
Correct, Your Honor.
Now show me how Mr. Hagan's office is going to see that when they download it.
Click on
Very
it.
good, Your Honor. The again, this top entry shows download single started. Shows that Mr. Hagan's office did commence download proceedings of that file.
But they couldn't wait 5 hours.
I have confirmed that the file as it appears on page 8 of the report is what would be observable to counsel for the defense at that time upon successful completion of the downloading process.
Keep going.
Okay, so he would see this screen that I'm looking at now, the black one.
Yes, Your Honor.
Okay, so I won't know that this, how do I know that this black screen is that white screen that he downloaded?
Oh my.
What's the name of this document I'm looking at?
This is the highlighted portion is the KBI lab results, Your Honor.
I know, but I'm saying, does this,
That it's not even. We won't even have to wait till then. She's gonna be here in a month, so when she's here, just tell her to do it, and she'll be like, "Oh, we'll put that on stream." You just have to tell her that you want to see it, and I'm sure she'll do it. And I won't have a say in it, so it's not like I can agree or disagree. If she gets in her head that she gets to do my nails, she's gonna love it. So, but you got to tell her that, guys. And I think she already went to bed though. She had like a 14-hour workday, so she jumped in and said hi and then crashed. So, just so you know. Anyways, thank you so much for the super chat. I appreciate it.
document with all these subcategories of what's on there have any kind of corresponding name to what I was looking at there a while ago on the white screen?
Yes, Your
when he was
Honor.
downloading it?
Yes, Your Honor. In the approximately a third of the way from the top, you will see a zip file entitled 23FG300002.
On the black screen?
Yes, Your Honor.
Okay, I see that.
And going back to page 1, the download single started includes a file name by the same name, 23F.
Is that a thing?
So Super Friday, it's always been called Super Friday because I don't know who started it, but it's the first and third Fridays of the month. And that is where all misdemeanor pretrials for attorneys are set. So we don't do pretrials with attorneys like 5 days a week. It's literally twice a month, first and third Fridays. So they used to have 25 or 30 cases regularly on each of those days. And then it's been dropped down to, I don't even know how many. Andy's handling them. He's got a few more weeks. And so just letting him do that while I handle felony stuff. And so we'll see how it goes. Maybe I should pop for fun, like just to give Andy some crap. I've known him for a long time. So
you should walk behind him while he's on the record and just scare the crap out of him and just see how he reacts.
No, he's got a cane right now. And he has I think his knee or his hip. I can't remember. Redone. And I was like, let's not injure him.
What? I didn't say injure him.
Well, if I scare him, but those chairs are not very sturdy in there. So.
Okay, fair. Don't do that. That was a terrible idea. I recommend you do not do that.
Well, and the other thing is it with Middleton tomorrow or with Pattison?
I don't know. Middleton. I don't know.
So usually.
Oh, tomorrow is Friday already.
Yeah. Usually when we're fully staffed, we would have like one attorney prosecutor in the courtroom and then one or two in the back so that we could keep cases moving. And it gets to the point where sometimes if you're going to resolve the case that day, you give your offer in the back room, which is literally right behind Judge Middleton's courtroom. So sometimes when some of us are loud talkers, he'll go and like open the door and be like, you guys got to quiet down. Not to me, obviously. I'm very, very demure at court.
No, he just calls you out from when you're pacing because he can hear you down the hallway.
Yeah, it's true. Anyway, it's nice to have a prosecutor in there because sometimes if the judge is just going to dispose of the case that day and we want to have some sort of a say or the factual basis, the defendant gives some, version of it that maybe we aren't in agreement with, it's nice to have a prosecutor in there. So maybe I will go down there tomorrow. We'll see.
You should definitely go down there on Tuesday, though. Just saying.
Yeah, well, I'm telling you, there's literally one prelim. And if we do, it's going to be a good one. It's interesting anyway. So I guess we'll see.
Well, let's hope it goes.
FG 300002.
So the black screen is what's contained in the first white line up there that says video 1 and 84 video 1. File name 819. Which one is it?
Right, the highlighted portion just above, Your Honor, file
Okay.
23FG 300002.
All right, then what's all that other stuff that says it's been downloaded? All those other that aren't highlighted underneath the yellow?
Your Honor, those are download portions of the associated media with the case. The state's understanding is that is not currently an issue
Okay.
by counsel for the defense's motion, and so the state did not highlight that portion in its report.
All right. So, Mr. Hagan, did your office get or download 23FG3 with all the zeros 2 in it?
Well, Your Honor, I'll have to get with staff to see all
come-
that. But I can tell you,
Were you saying something?
So now he's gonna throw his staff under the bus. Like, oh, I gotta get with my staff. Wouldn't that be the first question you ask? Is, hey guys,
Yeah.
whoever's in charge of this at my office for defense, show me what you did. How did this work? To just go and file a motion and claim that a prosecutor didn't turn over evidence, that's pretty significant. If you're going to do that, you better make damn sure that your staff did what they were supposed to do. And not even the staff at that point, I would get the download link myself and click on it and try to figure it out. Every day, it seems like we have somebody who contacts our prosecutor's office, and our county IT people will help them because we have, it's like a Cerebus account, whatever, like it's the name of it. We drop stuff into it. They can then download it out of it. But sometimes it doesn't work. And we have our staff trained to help walk them through it. And then again, our county IT helps them too. But I wouldn't, as an attorney, depend on my staff completely. And if they can't figure it out before I file a motion accusing a prosecutor of something, I would make sure that I've tried to do it myself.
Yeah. And at what point, if you're in the prosecutor's office and this guy, he said he's called and asked for it, so he's trying to get this. At what point do you just say, I'm just going to print it out and just drive over to his office?
No kidding. That is one of the other things. It's like, sure, that costs money to us as the prosecutor's office, right? But it's something that needs to be done if the electronic process isn't working. And if he paid for it, then you've already gotten some of the costs back on it. I don't know. This is interesting the further it goes in. So I guess we'll see. The exciting conclusion, right?
Yeah, exactly. I don't understand this question. I don't understand. I don't know if you do. Weird probation time out of, I don't know.
Such a weird probation time out of Michigan. So I think what they're referring to is the fact that the state, I think the legislature made this decision, that you cannot force somebody to go on probation. You can't put them on probation unless they agree to be put on probation, which is weird. Like, most people are not like, yes, sign me up for probation. They would rather serve.
I've seen people take jail time on probation.
Yeah.
Yeah, it's like I'll spend 30 days in jail over being on probation for a year. I've seen people do that.
Right. And I mean, I get the idea of not setting people up to fail and, making it cost
Lifetime
prohibitive for them, but lifetime probation, there are very few of those.
Oh, I guess that's what they're asking. Lifetime probation. All right, I'm confused. I don't know what's going on now, but we got to get to this video because
Yeah.
it's been an hour. I don't want to keep Debbie.
Like,
I don't want to keep.
I'm a little tired and I really want to eat that ice cream. And I got to feed Chief. I don't even know where he went. He disappeared.
You can dip. You can dip whenever you want to. Don't feel obligated to stand.
I'm invested now. I'm in it.
All right. Okay. So I'm gonna let it play for a while. So if anyone has any questions, I'll star them and I'll ask later, but I'm not going to pause it for a while. Let's
We're not
let's let it play.
interrupting anymore. We're just letting it happen.
Yes.
Is I know that I asked, did you get everything printed off? Whatever, she could not print that off. Okay, we knew that back in March. Okay, when we came to court in June, you ordered the DA to give it to me. How hard is it? It took him 2 seconds to give it to me at the last hearing on 11/1.
Well, I certainly agree with that, is because, you know, when it came down to it, Mr. Regier was able to do what I'd asked them to do, or to order them to do at every hearing. We did get it within a matter of minutes. I mean, that problem I'm having is why are we going through all of this right now? It's almost like, I almost feel like I'm just kind of fighting somebody that's being obstinate, saying, I'm not going to rescind it because I already have. Now, maybe I'm getting the wrong impression, but
And Your Honor, if the
here,
court-
is that what it's come down to?
You
Your
ordered
Honor.
him twice, 6/17 and 8/19
Mhm.
in court, had to have a special court hearing, and you ordered it 2 times, and now he's trying to come up, well, we probably gave it to him electronically and he might have got it. No, I told you back in June I don't have it.
Okay.
Why are we fighting about that?
Yeah,
and Your Honor,
I'll let you finish your presentation, but I'll tell you right up front, I just don't understand. Maybe he had it buried in there somewhere, maybe he didn't. But would it have hurt to give it to him again? I mean, was this a matter of principle that somebody didn't want to give it to him because they already had? What's going on here? I just don't get it.
Your
Why
Honor,
my orders were ignored twice.
and if the court will permit me to continue, I will
Go
be able
ahead.
to answer that question. Your Honor, going on to page 2, the court will find 4 more highlighted entries indicating that counsel for the defense's office attempted to download the file on 2 additional occasions on March 12. And the court will also note that the download process was successful on that same day, also on 2 separate occasions. Those are highlighted portion entries 1, 2, 3, and 4.
Well, and again, I think that's consistent with defense counsel saying that they had tried to go back over it and find it. And that would be in March, and then he came in here in April and said, I'm still waiting on it.
And Your Honor, if I
Okay, go ahead.
Again, Your Honor, more of the same thing. Download more entries, download single started and download single successful on the same file. Throughout this entire ledger, the state has successfully tracked that counsel for the defense started download procedures and successfully completed downloading procedures on a total of 11 separate occasions, 3 times starting the procedure, 8 times starting the procedure, 3 times completing the procedure.
Okay, and you're saying that each thing that he tried to download there contained the black screen of documents.
Yes, Your Honor.
Okay.
And then finally, Your Honor, the court will note on this page 3 more purple indications.
What's the difference between purple and yellow indications?
Your Honor, the purple indications indicate where my office did re-grant the counsel for the defense access. The court will find, besides the first time that that access was re-granted back in March pursuant to page 1, this page, which I believe is page 4 of the report, will show 2 more indications where access was re-granted to counsel for the defense on July 1st, 2024 at approximately 9:02 a.m., on July 1st, 2024 at approximately 9:03 a.m., and perhaps most recently on November 4th, 2024 at 8:15 a.m.
So you're saying that you in essence gave it to him every time he downloaded it
Yes, Your Honor.
because it was in this file that he says it wasn't?
Yes, Your Honor.
Okay.
On 11/1, he sent me the blood test results?
I got it by,
That's
well, I don't
via,
think I got the actual report, but I remember an email indicating that it had been sent. Maybe he sent it to me. I don't know, but
And he sent it during the hearing. He took a break from our hearing on 11/1 and sent it to me, and then came back to court, and it took no time at all. So what is the reason that on 6/17, on 8/19, when I told him I didn't have it, couldn't he, that little 2-minute email that he sent to me, and you made it order, and I don't understand why he's not just doing what was ordered by the court, and here we are this months later because he wouldn't do it.
he's not your
I would like to have gotten this case over with.
well, and
The issue is his staff either didn't know how to get it extracted from the zip file, or their old computer system wouldn't do it, or they had insufficient data space to do it, or he just didn't want to look through however many pages there were. So yeah, did it take 2 seconds for the prosecutor to pull out the 1 or 2 pages and email just those two? Yeah, but he's not your secretary. Like, we have to provide the discovery to you. And as long as it's not, written in hieroglyphics or something that we converted it to, you got to figure it out or hire somebody to look through it and figure it out for you.
I saw a case, this is a couple months ago now, where the defense attorney was complaining that they couldn't receive the discovery because they didn't have a PDF file opener.
Oh, good.
And they were requesting all the discovery be put into Microsoft Word.
Oh, wow.
And that's what they were saying. That was what they were saying. Like, we can't receive the discovery. They haven't sent it to us. They're sending it to us in PDFs, and we can't open PDFs. Like, I don't think that's a them problem. I think that's a you problem.
Well, and that's the thing. A while back, years ago, when I was on the defense contract, like Walmart had a particular video player that the police had to send like an exe file. I'm not great at computers, okay? I'm just like trying here. But every time they would put it on the disc, they would have the reader or the player, and you have to download that. Then you could open the security camera stuff. It's gotten a little bit better now. Like, everything is pretty much set to be like an MP4 or MP3 something. But yeah, again, just because you don't like the method or the manner of the discovery doesn't mean that you didn't get it. And he's trying to say, oh, I didn't get it. I didn't get it spoon-fed to me, is what he's saying.
Real quick, I wasn't supposed to pause it for a little bit anyways, but now that we're paused. Tammy, thank you so much for the PayPal. I appreciate it. That was awesome of you. Thank you.
that's what it boils down to, is maybe, I mean, let's say, all due respect, Mr. Hagan, let's say the defense attorney was totally incompetent and just couldn't read the file. He came to court, he said he wanted the blood draw report. I ordered it. Why didn't you just give it to him like you did the third order, the third time I ordered it in November?
She's directing that to Regier, but she said Hagan.
What was the reasoning for that, Mr. Regier? I mean, I get all this, what you're saying here, and maybe it was there and maybe it wasn't, and I'm not going to get into who is somebody pulling my leg, is somebody pulling tricks, or is this just some kind of honest clerical mistake of not knowing how to read a file or not sending it? What I just want to know, I want to keep this simple. Why did you not just send him the report? Like I said, has it gotten too complicated in your system to just do what you did the last time and send it? Do you have an answer for that, Mr. Regier?
Your Honor, what I can tell the court is that the court will note that when the court made its orders back in June, my office did reactivate the file. I have conferred with my colleagues regarding that, and I have confirmed that whenever an update entry is entered, an email gets sent out to counsel for the defense, notifying them that they have been re-granted access.
So,
He wants a paper copy.
And Your Honor, one final point before the court makes its ruling. As previously referred to in the report, page 1 of the report does refer to multiple upload entries where the files were uploaded to the discovery file. If the court wishes, I am more than prepared to review all the other pages of the record, and the court will show that there have been no additional uploads since that initial upload.
So he's saying it's all been there from.
no, I think I've seen enough to understand your position and what your evidence today shows. Mr. Hagan, you don't deny that your office has tried to upload these files or has uploaded these files.
My office has tried and has provided me everything that they could print. That's why on 6/17 and 19, and you know, he says that these things now are all done. This is the computer telling you something, and I don't know whether, you know, I don't have access, and I haven't looked through all this stuff or what printed everything what he's looking at, because honestly I can't even read this because it's too small for me.
Well, I'm struggling.
So, but all I can tell you is I don't understand why you gave him a court order on 6/17, and then if he says, well, we sent it to you this way, and then you say on 8/19, you say, can you just give him that? Yeah, they don't do it. And then we come back on 11/1, and you don't even order it then, but goes back to his office and says he wants to get some information, and suddenly he can send it to me in 2 minutes. And he wasted 6 months of the court's time or continuing this out when they had just done what I asked them. And then I had to have you order it because they didn't do what I asked them. And then you ordered it 2 times.
He's old school.
And then on the third court date on 11/1, you don't order it because I have my motion. And now they suddenly provide it to me while he takes a break. So that's upsetting.
You know, district court it used to
But
not even
Mr.
till recently in Michigan anyway. You weren't entitled to it. Wait till trial.
What for? What discovery?
For discovery in district court cases for years. Like the fact that the prosecutors gave it to you was nice, but they didn't have to. It's crazy.
I didn't know that.
Yeah.
That sounds crazy. How do you prepare for trial if you don't know what the prosecutor's bringing?
It's district court. It was misdemeanors and things, so we're required to. And a lot of times,
Yeah, that's fair.
Misdemeanor, there may only be like a ticket. So it's really just the officers showing up, testifying, and kind of fly by the seat of your pants.
That's fair. I had something I wanted to say. I forgot. What's that saying? I'm going to butcher this saying. I've heard it a dozen times. I'm going to butcher it. If the law's on your side, bang the facts. If the facts are on your side, bang the law. If neither are on your side, bang the table. I feel like this attorney is
very. He's just banging the table, and I think he's
yeah
getting pretty hot about it because he's realizing that it was probably in there the whole time, and for whatever reason, his staff couldn't print it out for him. But
yeah.
There are no specific rules. And to be fair, judge didn't say hand deliver him a paper copy. So provide him that. It can be provided by a carrier pigeon. Not really, because that's not reasonable anymore. But back in the day, it could have been a fax, a telegraph. Nowadays, this is acceptable.
Yeah. All right. We're never gonna get through this video. There's been about 15 minutes left of this video for about 25 minutes. So.
Oh, okay. Well, we'll try.
All right.
Here, we can take the screen down unless there's something else specifically you want me to see.
Not at this juncture, Your Honor, and with the court's lead, the state will stop sharing its screen.
Thank you. All right, it's your motion, Mr. Hagan. You've just kind of recapped and explained. If there's anything else you want to say before I make a decision, I'll give you your last, and then I will let Mr. Regier respond, and we'll go from, I'll make a decision from there.
That'd be fine, Your Honor. So 22 KSA 2232 is statute. They need to have 180 days deadline, and I think we've passed that deadline. And there's exceptions, but I don't see an exception as material evidence unavailable. But here the evidence was clearly available, and it was ordered by the court multiple times. And it was such an easy fix, it took him about minutes. So if the prosecutor can show me under the statute that he meets the exception to the rule, which is he has 180 days, and I don't believe there is any exception to it, Your Honor.
All right, Mr. Regier, final word?
Yes, Your Honor. The
Final word.
the state's understanding is that when the court had ordered discovery, my office did take steps to comply with that. I think the record shows for itself in that regard.
In what way?
In that it shows that the discovery file was made available to the defense on multiple occasions. He initiated download procedures and successfully downloaded it on multiple occasions. The file was initially made available to counsel for the defense back in January, when counsel raised concerns to my office that he did not have access to the discovery file. My office did reactivate it for his viewing on multiple occasions, once in March, 2 times in July, and 1 time in November. The state's position is that all discovery has been provided with counsel for the defense, and therefore he has been made aware of all that. While the state does understand that historically discovery procedures may have involved just sending out a note just saying something out by mail and then taking a handwritten note. My office has progressed far beyond that. The report clearly shows that besides being reactivated and emails being sent to counsel for the defense multiple times, counsel initiated the downloading procedures of discovery and successfully completed it also multiple times. So for that reason, respectfully advances that counsel has advanced a meritless claim, and therefore, for those reasons, the state is moving the court to deny the defendant's motion to dismiss.
Agreed.
So the county attorney's office has progressed far beyond sending out documents. They even went through a phase where they sent out information on disks. Why? Let me ask a question. What did the state bill you for the discovery, Mr. Hagan? If you have that available, or if Mr. Regier has that?
I don't have that available, Your Honor.
Mr. Regier, what would the state have charged to open this file and allow him to look at it?
One moment, Your Honor.
Very well.
I agree. I think that's the angriest we've ever seen Regier. He doesn't usually smile. He doesn't show emotion at all, which is why he's been nicknamed AI. He just seems emotionless. And there's been jokes that with the second he takes off his tie, he's a completely different person. I would hope so.
Your
Honor, in response to the court's inquiry,
some discovery is not even available to be sent to the other side, like CSAM, child stuff.
Yeah.
Their only option is to make it available to the defense, and we like have law enforcement like set up a time that they can come and they're entitled to be able to see it. But this whole idea that he didn't like the form that the discovery was sent to him in really bothers me. Like, I'm on team
So how do you think?
this one. He followed the court order. There wasn't an order for him to print out and hand to him the 2 pages or whatever that it is. It was to provide it to him. It's provided to him. If he can't figure it out or his staff can't figure it out, then get an IT person, like hire an expert. If I don't speak Spanish and the stuff is in Spanish, I'm gonna have to get an interpreter. He needs to get an interpreter for his inability to open zip files.
Just buy. He just needs to buy his nephew a pizza. Like, hey, can you figure this out?
No
for me?
kidding. Like, get any 5th or 6th grader over there. I'd be like, hey, open the
Yeah.
file. Not even joking. Would have been over.
States believes the standard fee in these types of situations is $25.
All right, $25 to let them access and download your file, basically. Is that right?
That is my understanding, Your Honor.
All right, well, so you're not charging him per document or anything like that, like you would have done in that era before you progressed so far.
Yeah. Like $1.
So let's say you get an attorney, an old school attorney that hasn't progressed technologically as far as you have, but is still a darn good attorney. Is he going to be denied discovery because he doesn't know how to get into your system?
No.
Your Honor, I have had the chance to previously communicate with my colleagues regarding this matter. Had counsel for the defense requested discovery in a specific format, my office certainly could have addressed that at the time, but it is the state's understanding that counsel for defense never requested discovery in a particularized format.
Well, maybe I'm just too unadvanced as well, but I thought when I ordered you to give it to him, you would give it to him and not just say, well, look it up on our file. I expected you to do like you did the last time and give him a copy of the document. But you're saying if they don't specifically ask for it in written form, you're not going to give it to them. Is that the way you usually proceed?
Your Honor, this is the exact same software that my office uses for every case. The court can speak to Mr. Andrews, Mr. Patterson, Mr. Page, whomever, and they will, and there's nothing special about this case. Again, the state's on the limited issue of whether or not discovery has been provided. The state maintains that discovery has been provided. Counsel for the defense never contacted my office for it in a specific format, only that it be provided. And for that reason, the state does maintain that discovery has been complied with in this matter.
Agreed.
Well, the attorneys you mentioned are all very local, but work probably the majority of their cases with your office. Mr. Hagan, I know I don't see nearly as often, but I don't think he should be handicapped or disadvantaged because he doesn't work with your office on a regular basis and use your system on a regular basis. Maybe he and his staff do, but whether you gave it to him and whether he downloaded it is not the primary concern the court has in this case. The primary concern I have is that I myself, as the court, specifically said, give him the report. Now, I'm not as new tech savvy as a lot of you are. And I'm used to the way the laws were written. Maybe they're not, I don't know I haven't looked recently to see what they say about, can discovery be given the way your suggestion? Can it be given the way I'm suggesting? But when I say give it to him, I mean give it to him. And I feel like, again, maybe that was not the county attorney's office's intent, but I just felt like when I said give it to him, the response was, well, we already did, and we're not going to do it again. Now, from what your evidence shows today, maybe that wasn't your intent, but he paid for discovery. He's entitled to discovery. And he's asked for it for so long, so many times. I've ordered it so many times that I'm not going to accept the concept. I guess what you're saying basically is I should have gone in there and looked for it. If that's all the responsibility is to put it on a screen and say, well, go find it, go get it, then maybe that's what you expected me to do too when I told you to give it to him.
Your Honor, that is not the state's intention in advancing this argument.
Thank you. Well, I appreciate that. I hope it's not. And I take you at your word on that. But somehow there has been a real breakdown on this particular case of, I can't believe we've gotten such an issue out of this that it's come to this point. I know when I say give somebody discovery, I mean physically give it to them.
Well,
Don't
then
just say, well, there's a website out there, go look for it. So for these reasons, because I feel like my orders were not enforced, I am going to grant the motion at this time. I'm not happy about it, and I don't like I said, I don't know how we got here, but I know that I gave several orders over the course of months, and I don't feel like my orders were enforced. I don't think, if my orders had been enforced, I don't think we'd even be here today. There'd be no doubt he had the discovery. But when you start relying on computers exclusively and
you've got to be kidding me.
not even considering other options, even if they may seem archaic, I think we're going to, from time to time, run into a problem. And I don't like this, but I feel like it is appropriate based on the statutes and the facts presented that I am going to dismiss this. I particularly do not like this because of the charge involved. And I sure don't want the defendant to think he got away with something that he may or may not have. But
yeah,
voting under the influence, driving under the influence, is one of the most dangerous things that can happen. And I sure don't like this, but I feel like, again, based on the law and the facts, and it's the only right thing I can do.
no,
So that's my order.
no. I'm going to have to fly.
Yeah, that happened.
Tell Regier,
But
I feel bad for him.
But can't Regier can just refile it? Can't he just, okay, you dismiss it and just refile it the next day?
Dismissed with prejudice, because if it was an issue of 180 day, I don't know what their 180 day rule is out there, but that is such a miscarriage of justice to me. Like, just because you hire an attorney that doesn't regularly practice in there, and so he's maybe not familiar with the discovery software, he had it provided to him multiple times, had it provided to him. And if he needed somebody to print a copy for him, maybe he's one of those difficult defense attorneys that they're like, why would I do anything extra for you? Because you're acting like a spoiled bratty child when you're in here pounding the table. But it just seems crazy to me. Like, it was provided.
She's gonna say in 1 second that it's without prejudice. So
Okay, good. Whew.
Yeah, Jay Regier even says that in a second. I paused it here because there's about 10, just I don't know, 15, 20 seconds left of the video. So I was gonna just say bye and let it play out. But yeah, so Regier does say, like, I reserve my right. Like, you could tell he's upset. He's like, I reserve my right to refile this.
Okay,
And,
so before
and Judge Webster said, okay.
So, all right, as a defense attorney prior, obviously Regier has strong feelings about this case and he's going to refile it. So, where does that leave your client, defense attorney? Do you know where it leaves him? Getting rearrested, having to rehire an attorney, starting the process over. Or you could withdraw your motion and say, you know what? Obviously, there was a breakdown in communication here, but we have it now. It's been a year. Let's do the trial. But no, he's going to let his client be put in a worse position. Like, that's crazy to me.
Oh, he's gonna take the win. He seems like that kind of guy. He's like, oh, I just got this guy off of a essentially a DUI, of voting while intoxicated.
But now
it's like, I just got him off. Like, I'm so good.
you think, like, what is he going to rehire you? If he does, I'd be like, I'm only rehiring you if you can figure out the damn discovery software so that we don't have this problem again.
Right.
Like this.
And is he gonna have to pay him the entire cost again?
I mean, technically, yes. Unless the guy's like, yeah, sure, I'll do it for free for you, because I don't know many attorneys that would do that. But yeah, he could go hire somebody else. He could get a court appointed. So now their county is paying for him to have legal representation because his attorney was too stubborn to figure out the IT issue. Really frustrating to me.
I am also grateful for your insights tonight.
Oh,
because I thought I really wanted to share this case. It was really interesting. I just don't know enough to be able to make this, interesting, engaging, entertaining. So that's why I reached out to you. So I am so happy you're here.
Crazy too is, like, this is a very judge-specific ruling, because if this were, say, a judge that is more technologically advanced in a county that is more technologically advanced, everything is paperless. Everything is like, here's your link. I don't think this would fly with the judges that are, in our county. There's an AI work group task force that's, working on using AI and how that can be helpful for the court system. Those types of judges would have said to the defense attorney, in my opinion, yeah, this is on you. Like, they provided it to you. If they can show me that when I click on this, it brings up, an 80-page document, and maybe it is buried. This is the same idea as in the olden days where, oh, you want discovery? Sure, we'll give you everything. And they send copy boxes full of papers. So to me, this was not a great ruling.
I agree. As of the first video I did, I was on the defense side. Like, why aren't you sending the discovery? So I understood that. But after Regier spent way too much time going through his process, where we finally ended up in the right place. Like, oh, he did get it. Then it was like, oh yeah, he got it. I don't know what else is there to. How are you still arguing? He received what he asked for, and why he filed his motion. He had it.
Right. It's not like he put some sort of special code or lock or something on it where, oh, here it is, but you can't download it. No, it was there.
Exactly. Yeah, I agree. Well, Debbie. Yep, I'm gonna let you go. You can still hang around. I'm gonna read off the couple of the super chats that I missed, and then I'm gonna let it play out. But you can stick around for the rest of it. Yeah, there's about, like I said, there's about 15, maybe up to 30 seconds left. You'll see Jay Regier kind of get a little upset, but I know I missed one early on, and I want to make sure I get it. Brian, thank you so much, Brian. I hope you're still here. I was just going through to make sure I got everybody, and I saw that I missed you about over an hour ago. So Brian, I really hope you're still here. Thank you so much for being a member for 3 months. That is awesome, Brian. Thank you.
Sorry,
We have Erica.
and like just talked over him and he missed you. So I'm sorry.
Yeah, we'll blame Debbie. No, I'm not going to. I'll take that. Erica, a member for 9 months. Thank you so much, Erica. Erica was on a live stream last night with a friend of the channel, KFAR. That was very entertaining. So Erica, really good to see you. And then C-Dumps with gifted membership. Thank you so much, C-Dumps, and welcome to the new member. C-Dumps, that is awesome. Thank you. I started this. I used to be a chef. You're not wrong, but I wore this hoodie specifically because people think that my icon, here, I'll show you.
I can see Chef White. It does, in fact, remind me of a chef.
People think I'm just talking on the icon, which I usually do because my internet sucks, so I don't usually go on camera. People think I'm wearing a scarf or an ascot. So tonight I'm wearing the exact hoodie that I was wearing in that picture. So it's like, it is a hoodie. I promise it was a hoodie. Wasn't wearing an ascot. Not that there's anything wrong with that. It's just not what it is. All right. I think that's it. I think I'm caught up. You guys are all awesome. Debbie, again, thank you so much. I have a great what do they call it? Fabulous Friday? Not a Fabulous Friday. What are they? Super Friday?
Friday? Fabulous Friday is better.
Super
You
Friday.
wanted to change the name of why is Super Friday? Like, we need a cooler name, but we haven't been able to come up with anything.
Fabulous Friday.
Fabulous Friday. All right. Well, hey,
All right.
Maybe I'll be on there. We'll see. Got some meetings and all the things, but I'll see you next week. So that's fun.
Fab Friday.
Yes.
Yeah.
Friday.
Yes. Next week. And I got some donations for gas money. So you guys are awesome. This was a great night. Had Debbie on stream and had a good case.
It is pricey, right? Like, he needs some donations for Yoders so that we can.
Yeah.
I think Tuesday is like food day, and there's always the ice cream and stuff. But so anyway, well, hey, thanks for having me on. I appreciate it.
Yeah. Again, yeah. Big coming in late with the super chat. Colin, you missed the super chat. This is a common thing with me is I am so paranoid of missing super chats that I go through, like I just did. I go through to make sure I got everybody. But people will start saying, like, you missed a super chat because I'm paranoid about it. I'll go back through just to make sure I didn't miss it, and I didn't miss one. So it's like, thanks for wasting like 3 minutes. Like, oh, I get it. It's a joke. It's funny. Because I'm OCD about super chats. All right, Vic, you're awesome. You got that little jab in. All right, we're gonna let this play out. Debbie, again, thank you. And we're gonna see Regier get a little animated right at the end. And while this is playing out, I will go find someone to raid. It is late, so we're probably gonna go to Lone Wolf. I think he might be the only one out at this point. All right, you guys have a great night, and I will see you guys tomorrow. And I'll see you next week, Debbie.
Yes. See ya.
This case is dismissed.
And Your Honor, if the court is dismissing this case under the circumstances, the state does reserve the right to refile at this time.
Well, I'll leave that decision to you. I'll leave any appeal decisions to you. Those are yours to make.
Thank you, Your Honor.
All right. Thank you, gentlemen.
Thank you, Honor.
In recess.
Thank you.